Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and hello to Dr. Soni and those who are watching this video. My name is Nur alias Asmida binti Bahtir Effendi, and today I'll be presenting a case review on the case of Pushpaleela, daughter of R. Selvarajah, and another, and Rajamani, daughter of Meyappa Chettiar, and other appeals. First, let's start with the fact of the case. The plaintiff in this case, Rajamani, daughter of Meyappa Chettiar, is an Indian national and bearer of Indian passport number X205536. She was the original registered proprietor and lawful owner of a parcel of land known as EMR 6527. However, without the plaintiff's knowledge and consent, the land had been transferred by a fraudster who had a name identical to her. The land was transferred to a third party who subsequently sold the land to another. The original document of title to the land was in the possessions of the plaintiff, yet the transfers were made using a computerized issue document of title with assistance from Shailen Arjunand, the seventh defendant, who was a lawyer who acted for Infinite Income Sdn Bhd, the second defendant, in the purchase of the land. The advocate and solicitor who acted for the fraudster at all material times was Pushpaleela, daughter of R. Selvarajah, the third defendant, who is also a partner in the law firm Messer M.Y. Chong, Pushpa & Co., the fourth defendant. The fraudster had produced an original statutory declaration in order to pass as the plaintiff. She affirmed before an Indian notary public stating that she was the bearer of Indian passport number X205536 and she had reissued with a new passport number F4495077. Pushpaleela, daughter of R. Selvarajah, the third defendant, believed the fraudster to be the plaintiff and asked her to execute the transfer form and the sale and purchase agreement for the sale of the land to Infinite Income Sdn Bhd, the second defendant, for the sum of 1.2 million ringgit. The seventh defendant had assisted the fraudster to apply for the issuance of a replacement title on the ground that the original title was lost. The replacement title, GM 9890, arising out of the sale of the land by the fraudster, was issued in the name of Infinite Income Sdn Bhd. Consequently, Bank Development Sdn Bhd, the first defendant, had purchased the land from Infinite Income Sdn Bhd, the second defendant, for the sum of 1.8 million ringgit. The computerized document of title GM 9890 was issued for the land in the name of the first defendant as registered owner. After realizing that the land was transferred, the plaintiff also contended that the transfer of the land to the second defendant was facilitated and effected by way of a duplicate title to the land wrongly issued by pentadbir Tanah Daerah Klang, the fifth defendant, or pendaftar hak milik negeri Selangor Darul Ihsan, the sixth defendant, through acts of fraud or deceptions of others, and without prior proper inquiry by the fifth defendant or sixth defendant to verify the authenticity of the applications for the duplicate title and the proper identity of the applicant. The plaintiff therefore lodged a police report and filed a suit against the seven named defendants on the grounds that they were liable to her losing ownership and interest to the land. As you could observe in the whole case, there were 6 claims issued by the plaintiff. The first one, the plaintiff contended that the transfer of the land to the second defendant was enabled by way of a duplicate title to the land wrongly issued by pentadbir Tanah Daerah Klang, the fifth defendant, or pendaftar hak milik negeri Selangor Darul Ihsan, the sixth defendant, through acts of fraud. Next, the plaintiff resisted that there is no proper inquiry by the fifth defendant or sixth defendant to determine the authenticity of the application for the duplicate title and the proper identity of the applicant. Third, the plaintiff asserted that a transfer of the land in favor of the second defendant and then to the first defendant was based on a wrongly issued title and was void ab initio. Next, the plaintiff argued that the transfer was procured fraudulently and or through forgery because the plaintiff neither knew nor dealt with the second defendant. Next, the plaintiff claimed that she never engaged the services of the solicitor, which is the third defendant and or the fourth defendant, and that they had acted negligently by acting for the fraudster. Lastly, the plaintiff also alleged that the seventh defendant acted fraudulently with the third and or fourth defendant for having facilitated and caused the transfer of the land to the second defendant. In this case review, the claim that we will be discussed is the claim on the third and the fourth defendant. This case had been brought to the High Court and the Court of Appeal. The High Court dismissed the plaintiff's claim and held that the third and the fourth defendants who acted for the fraudster did not owe a duty of care to the plaintiff by relying on the Court of Appeal decision in Yap Hamso and Fatimawati binti Ismail and others and another appeal, which the High Court found itself to be bound by it. The High Court observed that the third and the fourth defendants were in fact potentially negligent in failing to further investigate into the identity of the fraudster. However, as found by the High Court that there was an absence of a duty of care, the plaintiff's claim in negligence against them failed. In Court of Appeal, the plaintiff brought an appeal against the decisions of the High Court concerning the plaintiff's claim against the third and the fourth defendants. The Court of Appeal reversed the decisions of the High Court and found that the third and fourth defendants liable and negligent. It was held that the case of Yap Hamso is not authority for the blanket proposition that a solicitor never owe a duty of care to the third party, and a solicitor may, in certain circumstances, owe a duty of care to a third party. Upset by the decisions and orders of Court of Appeal, 3 separate leave applications were filed by the first, third and fourth and seventh defendants respectively for leave to appeal to the Federal Court. Let's move on to the issues of the case. There are 4 issues relating to tort in this case, which are the first one, whether lawyer owed a duty of care to plaintiff as real owner of land when lawyer was acting for fraudster who claimed to be the owner of the land. Second, whether there was a factual forcibility. Third, whether there was a sufficient legal proximity between parties. And last, whether there was a policy consideration against imposing such a duty. In the Federal Court, there are 3 questions of law raised. The first question is concerning the appeal by the third and the fourth defendants. In deciding whether a solicitor who acted for a fraudster, owner of land who sold the said land owes a duty of care to the real owner of land, the question is whether the Court of Appeal decision in Yap Hamso and Fatimawati binti Ismail and others and another appeal, or the Court of Appeal decision below is the correct decision. The second question is concerning the appeal of the first defendant. The question is whether a replacement title in continuation generated by the land registry when the original issue document of title was at all material times in the possessions of the original owner is A. valid and capable of validly passing title to the subject land to a subsequent purchaser in good faith and for valuable consideration within the meaning of the proviso to Section 340 subsection 3 of the National Land Code, or B. void ab initio and incapable of so passing title. The third question is concerning the appeal of the seventh defendant. The question is, can a specific plea of fraud against a person for acting in concert with others stand when the plea of fraud against the others is withdrawn? The only questions that we will scrutinize in this case review is the first questions of whether the Court of Appeal decision in Yap Hamso and Fatimawati binti Ismail and others and another appeal, or the Court of Appeal decision below is the correct decision. Before I proceed into the analysis of argument by both parties, it is significant for us to understand the status quo or the circumstances of the said case of Yap Hamso. So what happened in that case is undoubtedly similar to the current case. In the case of Yap Hamso, a solicitor had acted for the fraudster who purported to sell land on behalf of the owner under a forged power of attorney. The plaintiff was the real owner of the land. The first defendant was the solicitor who attested the forged power of attorney. The second defendant was the solicitor's firm who acted for the fraudster, and the DW5 was the solicitor in charge. The third defendant was the first purchaser of the land. The fourth defendant was the subsequent purchaser of the land. The fifth defendant was the land registrar. The Court of Appeal, by referring to the case of Neo Su O and others and G. Ratinasamy, upheld the opinion of Gan Chit Tuan Judge in emphasizing that a solicitor's duty is to use reasonable care and skill in giving such advice and taking such action as the facts of a particular case demand. To quote his judgment, he said that DW5's duty of care is confined to the forger alone and not to the plaintiff. She had performed her duties as a solicitor in the preparation and execution of the legal documentations, namely the memorandum of transfer and the sale and purchase agreement in favor of her client. And when she was unable to get her client's cooperation, she decided to discharge herself. Next, let's take a look into the submission by both of the parties. The learned counsel for the appellants argued that the Court of Appeal in Yap Ham so correctly decided that a solicitor who acted for a fraudster client did not owe a duty of care to a third party owner of the land. Learned counsel submitted that the Court of Appeal in the present case erred in law in holding the third and the fourth defendants owed a duty of care towards the plaintiff. In supporting the argument, the counsel mentioned that the such case law from Malaysia, New Zealand, Canada, United Kingdom, Singapore and Australia all illustrates that solicitors do not owe a duty of care to non-clients except in a very limited circumstances, i.e. disappointed beneficiaries cases, and where there is reliance. Learned counsel gave emphasis to the fact that the present case is not a disappointed beneficiaries case and there was no reliance. Next, the counsel argued that the loss to the plaintiff was not foreseeable consequence of the conduct of the third and the fourth defendants. The counsel also submitted that there is no legal proximity between the plaintiff and the third and fourth defendant, since the plaintiff only suffered pure economic loss and it requires a more restrictive approach to impose a duty of care. There must be some special circumstances, i.e. reliance and assumption of responsibility to show proximity between the plaintiff and the third and the fourth defendants. However, the counsel contended that the only nexus between the plaintiff and the third and fourth defendants is the plaintiff's interest in the land, which does not create legal proximity, where the plaintiff was never the third and fourth defendant's client and the plaintiff never relied on the third and fourth defendants who had no knowledge of the plaintiff's existence. In this regard, learned counsel for the third and the fourth defendant also intensified the court to the latest position in the Canada and United Kingdom case of NRAM Limited, formerly known as NRAM PLC, and still another, that solicitors do not owe a duty of care to non-clients where reliance on the solicitor was not reasonable. The learned counsel for the third and the fourth defendants also submitted that there are policy considerations against imposing a duty of care on the third and the fourth defendants toward the plaintiff. Imposing such a duty requires solicitors to assume that their clients are acting deceitfully and will put them in a position of potential conflict of interest. That would effectively make solicitors an insurer for all transactions, which would lead to increased costs that are passed on to the clients. On the other hand, the learned counsel for the respondent put forward an argument that the Court of Appeal in the present case was correct in holding that the third and the fourth defendants were liable in negligence. Learned counsel submitted that a solicitor in certain circumstances owes a duty of care to third parties other than his client and accordingly can be liable in negligence. In supporting their argument, the counsel highlighted the case relied by the Court of Appeal in the current case, which are the case of Ross and Countess, Penn and Bristol and West Building Society, and Al Sabah and Ali. The counsel then quoted that the Court of Appeal, in holding that the third and the fourth defendants were liable in negligence to the plaintiff, had considered these authorities to be good law on the matter of liability in negligence by advocates and solicitors to third parties in circumstances peculiar to the facts and circumstances of the present case. The Counsel also outlined that the Court of Appeal opined that in deciding whether a solicitor is to be held liable to a third party must depend on the facts and circumstances of each case. The Court of Appeal also agreed with the learned counsel for the plaintiff that the case of Yap Ham So is not authority for the blanket proposition that a solicitor never owes a duty of care to a third party. Moving on to the next sections of the case review, which is the judgment of the case. In the leading judgment by Azhar Mohamad Federal Court Judge, agreeing with the case authorities from Canada and New Zealand, pointed out that the Court of Appeal below had erred by taking an overly simplistic view in failing to appreciate that the solicitor must owe a duty of care to the real landowner before the court considers whether there has been a breach of the duty of care. The Court of Appeal appeared to have erroneously flagged the questions of breach, which is the solicitor's alleged negligent acts mentioned by the High Court in the current case, with the questions as to whether a duty of care was owed by the solicitor in the first place. Next, a careful reading of the English cases relied on by the Court of Appeal below also show that there are not authorities for a broad proposition that a solicitor who acted for a fraudster owner of land owed a duty of care to the real owner of the land. In fact, a review of case law in other Commonwealth jurisdictions show that generally solicitors do not owe a duty of care to third parties except in limited circumstances, namely disappointed beneficiaries in probate case and when there is reliance and assumption of responsibility. The Federal Court went on to consider whether a duty of care should be imposed on a solicitor who acted for a fraudster towards the real owner of the land by applying the threefold test of forcibility, proximity, and policy considerations. In examining the element of forcibility and proximity, their lordships found that it was not factually foreseeable to the solicitor that her act or omission might cause the real landowner to be deprived of her right to the land. This was because she had been retained as the solicitor for the fraudster, whom she believed to be the owner of the land and whose interests she is responsible for protecting. The expected scope of her duties covered the carrying out of the fraudster's instructions. The solicitor could not be expected to take into account the interests of the real landowner, whom she did not even know existed, not to mention on any knowledge of her interest in the land. It was not reasonable for the solicitor to inquire whether her client was really who she claimed to be or whether her client's action might cause harm to the real landowner. The court held that it was unrealistic to expect the solicitor to be able to guard the real landowner's interests under those circumstances. On the questions of legal proximity, the Federal Court pointed out that the real landowner only suffered pure economic loss, which usually calls for a more restricted approach. The court considered the questions of whether there was a voluntary assumption of responsibility by the solicitor and reliance by the real landowner to be important factors in establishing legal proximity between the parties. From the facts, it was plain that the only nexus between the solicitors and the real landowner was the real landowner's interest in the land, and this alone could not create legal proximity where the real landowner was never the solicitor's client and the real landowner had never relied on the solicitor. They never met each other prior to the commencement of the present action and did not know of each other's existence. The solicitor never assumed responsibility for the real landowner. As such, the requirements of forcibility and proximity in establishing a duty of care were not fulfilled. Next, in the matter of policy consideration, the Federal Court agreed with the New Zealand and Singaporean case authorities and held that Next, in the matter of policy consideration, the Federal Court agreed with New Zealand and Singaporean case authorities and held that there were policy considerations. Next, in the matter of policy consideration, the Federal Court agreed with the New Zealand and Singaporean case authorities and held that there were policy considerations against imposing a duty of care on solicitors acting for a fraudster owner of land towards the real owner of the land. Their lordships opined that imposing such a duty would require solicitors to assume that their clients are acting deceitfully and will put them in a position of potential conflict of interest. It would also effectively make solicitors an insurer for all transactions, leading to increased costs that are passed on to the clients. Such a duty would necessarily also extend to any agents for any person in any transaction, including accountants, bankers, insurers, stockbrokers, and any other manifestation of an agent. Taking into consideration of the above factors, the Federal Court declined to impose a duty of care on solicitors acting for a fraudster owner of land towards the real owner of the land and allowed the present appeal. The Federal Court then ruled that the answer to the leave questions, which is the first questions, was that the Court of Appeal decision in Meyappa is correct, and the Federal Court should not impose a duty of care on solicitors who acted for a fraudster owner of land who sold the said land towards the real owner of the land, as there is no forcibility, no proximity, and there are policy considerations against imposing such a duty. We have come to the last section of the case review, which is the commentary. I agree with the decisions of the Federal Court. Although at the first glance, I personally think that it is unjust for Rajamani, as he is a victim of fraud and he should get compensated by those who deals directly with the fraudster on the basis that they abet with the act of fraudulent. After a few thoughts and readings, I realized that it is indeed an undoubted fact that the duty of a solicitor is only to be bound with their clients and not to anyone else. The Federal Court is fair in the judgment, as we cannot expect that solicitors will have to act beyond its scope of duty in securing the interests of third party. The required scope of a solicitor duties covered the carrying out of the client's instruction without putting the burden to take into account the interests of the other third party, regardless of the existence of their interests. The decisions of the Federal Court is also significant, as it will lend some guidance to the scope of duty of care owed by other professionals to third party in Malaysia by re-emphasizing the applicability of the threefold test of forcibility, proximity, and policy considerations. That's all from me. I hope that you enjoy listening to the case review, and I hope that you will get some benefits from the case review that I present to all of you. Thank you. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.